for those subpoenas.
You did, and let me ask you, Mr. Smith, at the time you secured those non-disclosure orders, was Speaker McCarthy a flight risk?
The non-disclosure order was based on concerns about
Was Speaker McCarthy a flight risk?
He was not.
He was not. Then why did your non-disclosure order refer to him as a flight risk? It says right here, the court finds reasonable grounds to believe that such disclosure will result in flight.
16 days after Kevin McCarthy was sworn in as Speaker of the House, Jack Smith's office subpoenaed his phone records and got a court order sealing it, using language claiming McCarthy was a flight risk. Under questioning, Smith admitted on the record that McCarthy was never actually considered one. Both of those things cannot be true at the same time. Representative Brandon Gill thought he had a smoking gun. What he actually walked into was a lesson in how federal investigations work, because flight risk language in a non-disclosure order isn't about the person fleeing the country. It's standard legal boilerplate protecting the integrity of an active investigation. Smith also confirmed his office subpoenaed toll records for 9 sitting senators and another representative, with his own team's internal memo acknowledging litigation risk under the speech or debate clause, a risk they proceeded past anyway because they knew no one was likely to be charged. And no one would effing know. I'm Caleb Morgan. If you are new here, hit that subscribe button because we do not flinch and we do not let that slide. Let's get into it.
From Texas, Mr. Gill is recognized for 5 minutes.
Mr. Smith, in January of 2023, did you subpoena then Speaker of the House Kevin McCarthy's toll records?
Yes, sir, we did.
Yes, you did. And the subpoena covered the time period between November 2020 and January 2021. Is that right?
I'm sorry, sir. Could you say that again?
We're not going to delay like this. The subpoena covered the time period between November of 2020 and January 2021. How many days after Kevin McCarthy was sworn in as Speaker did you subpoena his records?
I don't recall, but those two things had nothing to do with one.
It was 16 days after becoming the highest-ranking Republican in the House of Representatives. You subpoenaed his toll records. Do you agree that that might reasonably be considered a violation of the speech or debate clause?
I do not, and I want to be clear that the toll
You
records...
were collecting months' worth of phone data on the Republican Speaker of the House, the leader of the opposition, right after he got sworn in as Speaker, all around the time of a major vote. That sounds like a flagrant violation of the speech or debate clause to me, and I think most people agree with me. And Speaker McCarthy had no recourse, did he? Because you issued a non-disclosure order ensuring that neither he nor any of the American people knew about these subpoenas. Is that right?
The toll record, the non-content toll record subpoenas, we did secure non-disclosure orders for those subpoenas.
You did, and let me ask you, Mr. Smith, at the time you secured those non-disclosure orders, was Speaker McCarthy a flight risk?
The non-disclosure order was based on concerns about...
Was Speaker McCarthy a flight risk?
He was not.
He was not. Then why did your non-disclosure order refer to him as a flight risk? It says right here, the court finds reasonable grounds to believe that such disclosure will result in flight from prosecution.
Sir, when securing a non-disclosure order, the risks don't have to be associated...
You think that the Speaker of the House is a flight risk?
The question?
No, this is not your time. This is my time. You think the Speaker of the House is a flight risk? You think he's going to hop on a plane and leave the country?
No, what I was trying to explain is with respect to a non-disclosure order, the risks aren't necessarily associated with the subscriber to the phone. They're the risks to the investigation.
I think that you were using, this was clearly in reference to Speaker McCarthy, and you were using clearly false information to secure a non-disclosure order to hide from Speaker McCarthy and from the American people the fact that you were spying on his toll records. But I've got more, so let's move on. In May of 2023, you also issued subpoenas for toll records of 9 U.S. senators and an additional representative. Is that right?
In May of 23, we did issue...
You did, and there were non-disclosure orders in conjunction with those subpoenas as well, right?
That's correct, consistent with department policy and the law.
So again, nobody would know what you were doing. The senators would, and the representatives would, and the American people wouldn't know what you were doing. Is that right?
The toll records that we secured and the non-disclosure orders were consistent with policy and consistent.
And you
with
knew
standards
whenever you were
that-
doing that there was a risk you were violating the speech or debate clause. Is that right?
The toll record subpoenas that we secured were with the concurrence of the public integrity.
Your own analysis says that you knew there was a risk you were violating the speech or debate clause. I have it right here. This is an email from John Keller at Public Integrity Section to your team. As you are aware, quote, as you are aware, there is some litigation risk regarding whether compelled disclosure of toll records of a member's legislative calls violates the speech or debate clause in the DC Circuit. That's from your own analysis right there. So you did know, didn't you?
Sir, with respect to the item you just put up on the screen, the last sentence states,
Oh, we're going to get to the last sentence.
okay,
We're going to get to the last sentence. And you cite case law in here, quote, the bar on compelled disclosure is absolute. Is that right? Or do you think that you didn't have to abide by that precedent?
to be clear, this statement is not from my office. This is the statement of the Public
This is
Integrity
your
Section.
justification for those subpoenas and NDOs that you ordered. This was part of your analysis. It's a cursory analysis. I think it's worth noting. But let's get to that last sentence then. Quote, given my understanding of the low likelihood that any of the members listed below would be charged, the litigation risk should be minimal here. In other words, you're using a novel legal theory, which you knew was novel, has never been tested by any court. You're not charging any of these members. Nobody's going to know about it because you issued NDOs. Nobody's going to sue about it, so who cares? We're going to do it anyways. I mean, you walked all over the Constitution throughout this entire process.
Mr. Chairman, the gentleman's time's
spying
expired.
on members of Congress, and you know it. It's absolutely disgraceful.
Let's start with the moment Gill clearly thought would be his viral clip, because it's actually the moment that falls apart the fastest. Under any real scrutiny, he pulls up the non-disclosure order, points to the flight risk language, and goes for the dramatic gotcha. Was Speaker McCarthy really going to hop on a plane and leave the country? And Smith gives him a direct answer. No, he wasn't. But here's what Gill either didn't understand or chose to ignore. That language isn't a personal accusation against McCarthy. It's standard legal boilerplate in non-disclosure orders designed to protect the integrity of an active investigation, not to claim the subject is personally a flight risk. Smith tried to explain that distinction in real time, and Gill talked over him because the explanation would have deflated the entire moment he'd built his questioning around. Now, let's actually sit with the underlying fact here, because it's the part that got buried under Gill's theatrics. This was toll record data, not wiretaps, not the content of calls, a list of who called who and when. During a specific window, November 2020 through January 2021, which happens to be exactly the window when an attempt was made to overturn a certified election. That's not a partisan fishing expedition. That's a federal investigator doing the most basic, foundational work of any investigation, establishing a communications timeline during the period the alleged crime occurred. The fact that McCarthy happened to become Speaker in the middle of that timeline doesn't make the investigation political. It makes the timing coincidental to an investigation that was already underway. Then Gill tries to escalate with the speech or debate clause, framing this as some unprecedented assault on congressional protections. And this is where you have to actually understand what that clause is for. It protects lawmakers from being punished or investigated for their legislative activities, floor speeches, votes, committee work. It was never designed to make elected officials untouchable witnesses in a federal investigation into an attempted insurrection. Gill's entire framing depends on collapsing that distinction, pretending that any legal process touching a member of Congress for any reason is automatically an attack on the institution itself. That's not how the law works, and Smith calmly said as much, even while Gill kept cutting him off. And then there's the part Gill clearly thought was his knockout blow. The internal DOJ email acknowledging litigation risk under the speech or debate clause in the DC Circuit. Gill waves it around like he's caught Smith admitting to a cover-up. But read what it actually says. It says, good lawyers evaluate risk before they act, which is not a scandal. That's competent legal practice. Every prosecutor, every defense attorney, every general counsel in the country does exactly this before making a consequential move. Acknowledging a legal theory hasn't been tested in court isn't an admission of wrongdoing. It's due diligence. Gill tried to turn "we did our homework" into "we knew we were breaking the law," and those are not the same statement, no matter how loudly you repeat it. The last line Gill quotes is the one that's supposed to seal the deal. The note that because these senators weren't likely to be charged, the litigation risk was low. Gill frames this as, "you knew no one could challenge you, so you did whatever you wanted." But flip that around and look at what it actually shows. Prosecutors weighing exactly how far a legal tool can be pushed within the bounds of the law, documenting that reasoning internally and using a legitimate investigative process, toll records, subpoenas, standard non-disclosure orders, to build a factual record during an active investigation into an attack on the certification of an election. That's not a constitutional violation. That's the process working the way it's designed to. What this hearing really exposes isn't prosecutorial overreach. It's a member of Congress walking in with a prepared narrative, expecting a career prosecutor to fold under theatrical questioning, and instead getting patient, procedural, fact-based answers that didn't fit the story he came in to tell. Smith didn't raise his voice. He didn't get rattled. He just kept explaining calmly how the law actually works, and let Gill's own selectively quoted documents undercut the very point Gill was trying to make with them. That's the real takeaway here. When you strip away the performance, what's left is a documented, methodical investigation into an attempt to overturn an election conducted using standard legal tools, reviewed internally for risk, and executed within the bounds of the law, versus a member of Congress trying to manufacture a scandal out of due process itself. So tell me, did Gill land a real hit here, or did he walk into a legal explanation he clearly wasn't ready for? Drop your take in the comments. If you want more hearings broken down like this, patient, fact first, no spin, hit subscribe. I'm Caleb Morgan, and I'll see you in the next one.